So we'll start. Very good evening to everyone. I am Anushmi Jain, Faculty of Law, the ICFI University, Dehradun. I welcome you all to this special guest lecture on Right to Information Act 2005, organized by Center for Environmental Law, Policy, Education and Development, also known as CELPED, ICFI Law School, the ICFI University, Dehradun, in association with Praja Foundation. I would like to take the privilege to extend a heartwarming welcome to our speaker for the day, Mr. Shailesh Gandhi, former Chief Information Commissioner. Thank you, sir, for accepting our invitation and gracing the event with your valuable presence. I would like to extend a warm welcome to Mrs. Monica Kharola, Assistant Dean, ICFI Law School, the ICFI University, Dehradun, and all the participants who have joined us today. Moving forward now, I request Mrs. Monica Kharola, Assistant Dean, ICFI Law School, Dehradun, for welcome address. Over to you, ma'am.
Thank you, Anushmi. It's my pleasure to welcome the guest speaker, Mr. Shailesh Gandhi, who was the former Chief Information Commissioner and who was also with us in a previous event and has been extremely helpful in giving the nuances of right to information. We welcome you, sir, to this guest lecture. I also welcome Mr. Aviral Dubey from the Praja Foundation and the Center of CELPAD, which has taken the effort of organizing this guest lecture. I'm sure that today's guest lecture will be highly fruitful to students as they look forward to such lectures in order to make their practice more effective and to be able to learn the law and how it is going to be implemented even better. So it's a great opportunity for all our students also and all the participants who are taking part in this event. I would, for the benefit of all, like to inform that ICFI University, which started in 2004, the 2003, and the law school, which started from 2004, has been consistently working towards making law and legal education more effective by trying to enhance the knowledge input through guest lectures and through various activities which are promoted even by Bar Council of India and according to the new education policy. In this process, we are extremely thankful to all our faculties and staff, and of course the students who take part in great numbers and who come forward to help in making this learning process more fruitful. So with this objective of making law more interactive and the learning process even more effective, we have been able to achieve certain rankings in the various ranking, the centers which are ranking different law schools, and among them CSR GHRDC has ranked us as one of the top in Uttarakhand, and among all the law colleges 13 which is given by IIRF ranking. So this ranking also helps us to do better, encourages us, and of course it is people like our guests today who come and deliver lectures and share their experiences that makes our work even more easy, so that we are able to give the best to the students. Without taking any more time, I would once again thank Mr. Gandhi for being here and sparing his time for being able to share his experiences about right to information. Thank you, and over to you, Anushmi.
Thank you, ma'am. Now I would request Mr. Vishal Bera, Faculty Convener at ICFI Law School, to introduce our speaker for the day, Mr. Shailesh Gandhi.
Thank you, ma'am. Good evening to all present in the meeting. And to introduce the speaker profile for the day, Mr. Shailesh Gandhi. Mr. Shailesh Gandhi is a first generational entrepreneur and a distinguished alumnus awardee of IIT Bombay. To our very shock, he first sold his company to become RTI activist. Then He became a part of the national RTI movement, which was actually involved in drafting the National Act. He then went on to become the convener for the National Campaign for People's Right to Information, which is famously known as the NCPRI. He is the only RTI activist to have been chosen as a Central Information Commissioner, and he disposed of a record of over 20,000 cases in 3 years and 9 months, ensuring most cases were decided in less than 90 days. He has given various landmark decisions on RTI. Apart from that, he has also organized the first digital paperless office in the Commission. He is a passionate and pursuing the cause of evolving ways for a time-bound justice delivery system and hereby improving the governance system apart from conducting RTI workshops and advocating active citizenship. He has published a book, RTI Act, Authentic Interpretation of the Statute, and a paper critic on the Supreme Court judgments of the RTI. So we welcome you, sir, and the floor is open to you, sir. Thank you, sir, for accepting our invitation.
Thank you very much for this, and thank you for the opportunity of talking to all of you. Friends, we say India is the world's largest democracy. When I was in school, I was taught that democracy is rule of the people, for the people, by the people. Question I have posed before participants all across the country: do you feel like you are the ruler of this nation? When you interact with government, do you get the feeling that you are the ruler of this nation at all? And the universal answer has been no, we don't feel like that. Then how are we a democracy, or has the definition of democracy changed? My submission to you, we called India the world's largest democracy because we have a reasonably fair system of elections by which we are able to change our representatives, change our leaders, change our governments. That is true. Having a fair system of elections and the constitution are necessary conditions for a democracy, but are not the complete set of conditions. The heart and essence of democracy is the concept that each individual citizen is a sovereign in her own right, and she gives a part of the sovereignty to the state in return for which she gets the rule of law. Sovereignty of the individual citizen is the key and heart of democracy. I would go further and say sovereignty of the individual human being is the heart of all human rights movements. Human rights arise because we recognize that all citizens, all human beings, have got intrinsic human rights because they are a human being. And therefore, we have the right to equality and all other rights that go along with that. In Hindi, we use the word Lok Shahi. Lok Shahi means logo ki shahenshahi. All of you, my friends, should feel like Badshahs or Begums of India. At one lecture, when I was giving such a talk, one young student got up and said, "Sir, are you serious?" I said, "Yes, I am." He said, "ऐसा कहीं होता है क्या? ये बातें तो अच्छी लगती है, चिकनी चुपड़ी लगती है सुनने को कि सब बादशाह और बेगम बन गए, मगर ऐसा हो सकता है क्या? Can you run a nation with 130 crore badshahs and begums?" And I'd like to quote two examples to you to illustrate what I'm saying. The first example is from the United States of America. I'm not saying everything there is fine, but in terms of democracy, they have a 2-century lead over us. An immigrant from India, Pakistan, Bangladesh, China, if he or she has applied for the green card or citizenship of America, will easily pick up the telephone and ask about the status of their application, whether it's in order, whether there are any defects, when is it likely to be considered, so on and so forth. And 99%, they will get a perfectly rational answer from the other side of the telephone because a human being is called. The second story I'd like to share, which all of you are aware of, but I want to give you a slightly different perspective. 125 years back, Mohandas Karamchand Gandhi got inside that train in South Africa. He had a first-class ticket, but there was a white man sitting who objected, and he was taken off the train. In that same story is written that Mohandas Karamchand Gandhi sent a telegram complaining about what had happened to him. And in about 12 to 14 hours, a railway official came and put him on the next train. Think of the significance of this story. Mohandas Karamchand Gandhi was not a citizen of South Africa. By South African law, then he was a second-rate human being, even as a human being, because he was not a white man. Despite that, 125 years back, he makes a complaint and the system responds. Today, you are all first-rate citizens. If you file a complaint with the Indian Railways, forget 12 to 14 hours, in 12 to 14 days, if you get an acknowledgement, you'd consider yourself lucky. Respect for the human being is the key to democracy. Without that, there's no democracy. It's a sham democracy. I call it a defective elective democracy. Because we have elections, we say we have a democracy, but that's a defective democracy that does not deliver the results of a true democracy. Right to information, I would submit, recognizes this respect for the individual and is a tool to establish this power and recognize the fact that the citizen owns the nation, owns the government. All of you, my friends, are owners of this country. You are the rulers, as I said, which means you rule the country, you own the country. At one other college again, one young person got up and said, "Sir, aap sahi kehte hain. Do you understand what you mean?" I said, "Yes, I do understand, I think." He said, "Supposing there's a government car and I like it, can I take it home?" I said, "You can't take it home." He said, "Sir, fir aap jhoot bol rahe hain. If I own the government, why can I not take government property home?" The reason I explained to him was that you are in partnership with 130 crore other Indians as owner of everything that the state owns. So if you take it away, you deprive the other 130 crore Indians. But, and this is important to understand, all the information in the files, cupboards, computers of the government also belongs to you. You own the information. Therefore, you have a right over it. And if that information is given to you, it does not deprive anybody else because that information can be given to 100 people also. Therefore, the default mode in right to information, the default mode of the Constitution is that information belongs to you and therefore you must have access to it. Ideally, you should have access to it without even asking for it. It should be available on the web. Having understood this, let's move on. The first such law, transparency law, was made in Sweden on 2nd December 1776, nearly 250 years back. After that, for nearly 150 years, no country had such a law. In the last century, around 130 countries have now established such a law, which goes by 3 different names: Freedom of Information, FOI, Access to Information, ATI, Right to Information, RTI. These are synonymous terms for the same concept worldwide. In India, the first movement started in rural Rajasthan with Mazdoor Kisan Sangathan in the early 90s. Aruna Roy, Nikhil Dey and Shankar Singh started this movement, and then it slowly grew. 2005, 12th October, the RTI Act became nationally effective. And that day was Vijayadashmi, a very significant day for India. What we're going to do today is I'll walk you through some of the provisions of the law. The law is extremely simple. Anyone can understand it. We must understand the law, and the law is what the words of a law say. You can interpret a law when there is doubt about, there are 2 or 3 possible interpretations. But otherwise, the words of the law must be followed. And this is extremely simple. I will share this with you now. I'll just share my screen. Is my screen visible?
Yes, sir. You can see
Okay.
that.
Yes,
And I'm
sir.
audible also.
Yes, sir.
Okay. Right to Information Act 2005, as I said, 12th October 2005, this started. Let's look at the preamble of this law. The preamble says, whereas the Constitution of India has established democratic republic, and whereas democracy requires an informed citizenry and transparency of information which are vital to its functioning, and also to contain corruption and to hold governments and their instrumentalities accountable to the governed. And whereas revelation of information in actual practice is likely to conflict with other public interests, including efficient operations of the governments optimum use of limited fiscal resources, and the preservation of confidentiality of sensitive information. Parliament was aware of these issues, but it thought it was vital to its functioning and to hold corruption also. And therefore, the Parliament did what? It said, and whereas it is necessary to harmonize these conflicting interests while preserving the paramountcy of the democratic idea, the harmonization has been done in the law. It is not left for people to harmonize the right. The law defines very beautifully how all these interests have to be brought together. Information. What is information? The definition is given there, but in simple terms, what exists is information, what does not exist is not information. This is right to information, not right to interrogation. If you ask under RTI, what is the meaning of this law? Most probably you will have no information because there will be nothing written on the records. If, however, there is written, the meaning of the law is written, then that would be given to you. If you say, if I apply for this job, will I get it? The answer will be, there's no information like this available. It must exist. So when you are asking for information, think of it like that. You ask for what exists and then derive information from there, derive other benefits from there. Who has to give information? The law defines what's called public authorities. Public authority means any authority or body or institution of self-government established or constituted by or under the Constitution, by any other law made by Parliament, by any other law made by state legislature. A, B, and C covers everything that we normally call government. Central government, state governments, municipal corporations, municipalities, panchayats, all of these organizations are covered under this. By notification issued or order made by the appropriate government. For example, all deemed universities are created by notification issued by the government, and therefore they are all public authorities and are subject to the Right to Information Act, and includes any body owned, controlled, or substantially financed, non-government organizations substantially financed directly or indirectly by funds provided by the appropriate government. If a body is owned, controlled, or substantially financed, it is a public authority. On the PMKS fund, there is an unnecessary controversy. PMKS fund, the chairman is the Prime Minister ex officio. 3 other ministers are ex officio trustees of this trust. They can only do this on behalf of the government since they are ex officio members of the trust. Therefore, it is actual government control. And PMKS fund should come and subject itself to the Right to Information Act. What is right to information? Right to information means the right to information accessible under this act, which is held by or under the control of any public authority, and includes the right to inspection of work, documents, records. You can inspect work, you can inspect a road, you can inspect a building. One young man in Mumbai went and said, I want to inspect a government hospital. So he carried out the inspection and discovered certain things that were wrong, put them on record, and that is now being improved. Taking notes, extracts, or certified copies of documents or records, this is what is generally done. You ask for information which can be extracted from existing copies or copies of documents. Taking certified samples of material. You can take samples of material also. For example, if you believe a government hospital has got fake medicines, you can get samples and get them tested. If the concrete work in a road is poor quality, you can get it tested. Obtaining information in the form of diskettes, etc. CCTV footage is a very important part of this now, because in various places CCTVs have been installed. And as per the Supreme Court's judgment, all police thanas, for example, have to have CCTVs, and they must keep their CCTV footage for 6 months. The most important section in RTI, I believe, is Section 3. Subject to the provisions of this Act, all citizens shall have the right to information. Who has the right to information? All citizens of India. Any citizen has it. It's a fundamental right guaranteed to citizens. Can any information be denied? So philosophically, you would say that if information belongs to me and I own the information, how can it be denied to me? However, to run a nation, some information would have to be safeguarded, and some information would, if given, would cause more harm than good. Therefore, those are listed in section 8 and 9 of the Act. We'll discuss this a little later. But apart from this, the denial has to be justified in the Act, in section 8 or 9. Default mode is all information belongs to you. Only section 8 and 9 cover information that can be denied to you. The Act does not permit anybody to say it's confidential information, hence we will not give it. Categories of information are described, which we'll deal with. Section 4 is called the heart of the RTI Act. Every public authority shall maintain all its records duly catalogued and indexed in a manner and form which facilitates the right to information under this Act, and ensure that all records that are appropriate to be computerized are within a reasonable time and subject to availability of resources computerized and connected through a network all over the country in different systems so that access to such records is facilitated. Records must be kept properly and catalogued properly. But 16 years down the line, the promise that the Parliament made was all records will be computerized within a reasonable time. 16 years is more than reasonable time. Computers exist in all the country. All courts have computers, all panchayats have computers, and they are connected over internet. Therefore, that exists. Unfortunately, most records are not computerized. People work on paper files. It's quite common for a citizen to go to a government office to follow up on a complaint or application and to be told, "Aapka file nahi milta hai." 100 रुपया दिया तो फाइल मिल जाएगा, 500 दिया तो रिकॉर्ड गायब हो जाएगा, 1000 दिया तो फाइल गायब हो जाएगी. All of this corruption can stop if only electronic records were used. On a computer, the file can be built and it can also be sent to various places as required for approvals of information over the internet. This would save thousands of crores worth of paper, files, space to keep these files, and the cost of locating these files. Quite often, these files are not found. All of this can be saved, and I'm hoping public pressure builds up sufficiently to get this implemented. Section 4, suo motu disclosures, that's expected. Over 50% RTI applications seek information which should be available under Section 4. Fair enough, we've understood what is information, what is right to information, which authorities have to give information. But how do I go and actually ask for information? The law says every public authority in all its administrative units must appoint a public information officer. And this public information officer is supposed to respond to your RTI application. It's his responsibility. You don't have to find out his name. You address an RTI application to the public information officer of an office where you believe the information is likely to be. What happens if it's the wrong office? Will he return it to you? The answer is no. If the information is available with other officers in the same department, he has to get it from them and give it to you. Alternately, if it belongs to another department completely, he must transfer the RTI application within 5 days. You are the sovereign of this nation, and your application cannot be just sent back saying, go and find the right department. It is the PIO's job to find the right department. A person who desires to obtain any information under this act shall make a request in writing or through electronic means in English or Hindi, or in the official language of the area in which the application is being made. You can apply in Hindi, English, or the local language of an area. In Tamil Nadu, it will be Tamil. In Kerala, it will be Malayalam, and so on. The response would be given in the language which the office is using. So just because you give an application in English, it does not mean the response has to be in English. It may be in any one of these 3 languages. An applicant making requests for information shall not be required to give any reason for requesting the information or any other personal details except those that may be necessary for contacting him. Some people say this is an unreasonable thing. Without any reason, why should somebody seek information? Go back to the concept. You own the nation. Everything in the government belongs to you. Therefore, you need to give no reason for what belongs to you to request information. For example, a drawer in the table in your house. It belongs to you. You do not need to explain why you want to open the drawer and take a look. It's your right, and it's your right under Article 19(1)(a) of the Constitution also. On receipt of a request under Section 6, PIO shall, as expeditiously as possible, in any case within 30 days of the receipt of the request, either provide the information on payment of such fee as may be prescribed or reject the request for any of the reasons specified in Sections 8 and 9. Rejection can only be based on Sections 8 and 9. Section 9 covers copyrights. So if something is copyrighted and giving information would violate copyright, for example, if you ask the censor board for the DVD of a film, that cannot be given to you because it would infringe on somebody's copyright. Section 8 has 10 clauses which we'll deal with very soon. Apart from that, all information has to be given to you. There is a fee, normally 10 rupees for an application fee. And for getting the information, supposing the information you are seeking is 200 pages, the charge is 2 rupees per page. So 400 rupees you will have to be asked to pay and you will get the information. And how to calculate the 30 days, we'll just take a look at. If PIO fails, supposing the PIO doesn't respond to you, in 30 days, if he has not responded to you, it's a deemed refusal without any reasons, which invite the penal provisions of the law. As I explained to you, further fees can be charged, and the period during which the fees are paid is not considered as 30-day period. Person making request for information shall be provided the information free of charge where a public authority fails to comply with the time limit specified in subsection 1, which is 30 days. In 30 days, if the information is not provided to you, even if the information is 2,000 pages, the PIO cannot charge you 4,000 rupees. He has to give you the information without any charge. 30-day period, I thought I'll just explain. PIO receives RTI application as day 1. After X days, PIO sends letter asking additional fees, 30-day clock stops. Additional fees paid, 30-day clock starts again. Information sent after Y days. X plus Y less than or equal to 30 days. If RTI application is transferred, as I said, for 5 days, they get for transferring the RTI application, the period will be 35 days. Now, when making an RTI application, it's extremely important to understand that what you have in mind is, unless you put it on paper, it's not meaningful. Do not put long stories. A good RTI application is short and focused. Generally, less than 150 words should be your information seeking. That is a good RTI application. When you start initially, if you're not too sure, draft an application and show it to a friend and see if it makes sense to that person. I've given you some samples of RTI applications. I'm not going to read them out. I've requested the organizers to part with this presentation to all of you. You can take a look at it. If you want to inspect files relating to something, here is a draft I've suggested. I want to inspect files relating to whatever subject. I will bring Mr. So-and-so to assist me in the inspection if you want to take somebody along with you. Please suggest 2 dates with the time at which I could come for the inspection. I will identify the documents for which I want photocopies at the time of inspection. Please ensure that the pages of the files are numbered. If the pages are not numbered, they may remove some records and not show them to you. What is the likely outcomes of an RTI application? PIO sends letter asking for further fees to be paid and the information obtained by the applicant. Satisfactory outcome, nothing further needs to be done. You get letter from PIO transferring your application. Further communications will be with the PIO to whom the RTI is transferred. You get letter from PIO refusing to give the information, quoting an exemption. If you feel exemption is justified, accept the decision. If you feel refusal is not justified, file a first appeal within 30 days. You must state reasons why you think refusal is not justified. PIO asks you to come for an inspection, refer to SIC orders. PIO does not respond at all. This is a deemed refusal without any reason. File a first appeal after 35 days, but before 60 days of the RTI application. Addressed to the first appellate authority. In all departments, there is a senior officer who is designated as the first appellate authority. How do you figure out who the first appellate authority is? The law requires a PIO to give you the details of the first appellate authority, but supposing he has not responded to you at all, or he's responded and not given details, what do you do? Simple technique is address your first appeal to first appellate authority, care of public information officer in the same address. And in that appeal, write that the law requires you to give me information about the first appellate authority. Since you've not done so, it is now your job to pass it to the first appellate authority. I want you to remember very carefully, RTI is a fundamental right of citizens under Article 19(1)(a), which guarantees freedom of speech and expression. Various Supreme Court judgments have held that this includes right to information and right to publish. We consider right to publish as being sacrosanct. Independence of media as being very important to a democracy. Right to information falls in the same category. Remember one thing, in the Constitution of India, there is no specific mention of right to publish or to media. It flows from Article 19(1)(a), freedom of speech and expression. Similarly, right to information also flows from that. Therefore, restrictions must be the same for freedom of speech, right to information, and right to publish. The only permissible restrictions are given in Article 19(2). If my rights under fundamental rights have to be curbed, they have to be allowed in the Constitution of India. Article 19(2) gives some reasonable restrictions can be placed in the interest of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation or incitement to an offense. These are captured by Section 8(1) of the Act, and we'll take a careful look at this. Section 8(1) of the Act comprises 380 words. If you understand that, apart from that, all information has to be given to you. Notwithstanding anything contained in this Act, there shall be no obligation to give any citizen information, disclosure of which would prejudicially affect the sovereignty and integrity of India, the security, strategic, scientific, or economic interests of the state, relation with foreign state, or lead to incitement of an offense. For example, Indian Army is a public authority under the Act. If you ask the Indian Army how they have placed their arms, or the soldiers at the border with China or Pakistan, that would not be given to you since it would be covered under exemption under Section 8(1)(a). B. Information which has been expressly forbidden to be published by any court of law or tribunal, or the disclosure of which may constitute contempt of court. Quite often, people refuse information, PIOs refuse information saying matter is sub judice. Sub judice is not a ground for refusal of information. The law categorically states has been expressly forbidden to be published by any court of law. If there is a specific direction of a court or tribunal saying that this information shall not be disclosed, only then can information be refused. Because it is sub judice, information cannot be refused. Information, the disclosure of which would cause a breach of privilege of parliament or state legislature. Information including commercial confidence, trade secrets, or intellectual property, the disclosure of which would harm the competitive position with third party. There's a larger public interest override which we'll deal with later. Supposing you ask FDA for formulation of Coca-Cola, that would be denied to you because it is the nature of commercial confidence which is not shared publicly, and it would harm somebody's competitive position. To understand this carefully, both conditions have to be satisfied. The disclosure must harm somebody's competitive position, and it should be in the nature of commercial confidence. Therefore, for example, Indian Railways cannot claim this exemption for information relating to it, whereas Air India or a bank can claim this because they are in competition. E. Information available to a person's fiduciary relationship. Now, what is fiduciary relationship? Some people say a relationship of trust is fiduciary. Yes, trust is one element of it. That's not the whole story. Let's look at what are traditional fiduciary relationships. Lawyer-client, doctor-patient, banker-customer. These are the traditional fiduciary relationships. Amongst others, there are others also. What are the characteristics of this relationship? The person who gives the information gives it for his benefit. B. The fiduciary is not expected to share it with others, but the person who gives the information can share the advice that he receives with anybody he likes. Equally important, he has a choice whether to give the information or not. A statutory requirement is not given in fiduciary relationship. Whereas if you give information of your own volition, you have a choice of who to give it to, and you have a choice of whether you want to give it or not. And if you do not give it, it's no violation of any law or rule. For example, I go to my lawyer, supposing I've committed a crime, I tell him I have not committed a crime, I am breaking no law. And yes, I trust that person. I will go to a doctor, lawyer, or banker because I trust him. If I do not trust him, I will not go. So trust is one element of a fiduciary relationship. 99% of the documents in government are not held in a fiduciary relationship, because to apply for a job, to apply for a passport, to apply for something else, or to apply for a permission, these are not fiduciary relationships at all. Information received in confidence from foreign government. Only in one place is the word confidence or confidentiality used, which is when information is provided by foreign government and the PIO says it's given in confidence, there can be no further argument. Information, the disclosure of which would endanger the life or physical safety of any person or identify the source of information or assistance given in confidence for law enforcement or security purposes. If there is some information, by giving it, somebody's life or physical safety would get impacted, then this information can be denied. Information which would impede the process of investigation or apprehension or prosecution of offenders. Very often, people have given a complaint and they know nothing is happening. So they ask for information regarding the progress of the complaint. And PIOs use this. It is a wrong use of this exemption because the person who's given a complaint will never try and impede the process of investigation. While the investigation is ongoing, also information must be provided unless it can be established that giving the information will impede the process of investigation. Cabinet papers, including records of deliberations of the councils of ministers, secretaries, and other officers, provided that the decisions of councils of ministers, the reasons thereof, and the material on the basis of which the decisions were taken, shall be made public after the decision has been taken and the matter is complete or over. This is a unique exemption. Up to a certain point in time, the information is exempt until a decision is taken by the council of ministers. After the decision is taken, the basis, the material, and the basis on which the decisions were taken shall be made public. Let me explain this a little bit. For example, when a bill is to be presented in Parliament, there is a discussion amongst the cabinet ministers and secretaries and so on. During that time, if you seek this information, it cannot be given to you. But once a bill is presented in Parliament, the bill is the property of the Parliament or the state legislature. What is imagined is that this should be disclosed suo motu by the government so that people, the citizens who are the rulers of this nation, can discuss or debate it. If this is done, a lot of protests against bills and acts will not happen. Unfortunately, this is not being followed in the letter and spirit of this law. 81J is a favorite for refusing information. Information which relates to personal information, the disclosure of which has no relationship to any public activity or interest, or which would cause unwarranted invasion of the privacy of the individual, unless the PIO, first the larger public interest we'll deal with later, provided that the information which cannot be denied to the Parliament or a state legislature shall not be denied to any person. We'll analyze this in the next slide. Notwithstanding anything in the Official Secrets Act nor any of the exemptions permissible in accordance with subsection 1, a public authority may allow access to information if public interest in disclosure outweighs the harm to the protected interest. There is no need to show public interest for disclosure of information. No reasons need to be given. It can be for private interest. It can be just because you want to ask for research what is happening. You need not give it. Just give me 30 seconds. I'll just join you back. Sorry about that. You need not establish any public interest for seeking information. What does this cover? For example, supposing you ask Punjab National Bank for transactions between Nirav Modi's companies and Punjab National Bank. they could claim exemption under Section 8(1)(e) as being held in a fiduciary relationship, which is correct. However, you might argue that there's a large scandal, and therefore there's a larger public interest in disclosure, and it could be considered giving you the information. Section 8(1)(j) that I dropped off, information could be denied if it was personal information, your name is personal, your age is personal. Almost everything to do with a natural person is personal. Personal information by itself does not get exempted, but it may fall under 8(1)(j), and disclosure has no relationship to any public activity or interest. 99% of the papers in government are the consequence of public activity. If I eat something at home, that's not a public activity. But if I have eaten something and submitted the bill to government, which has reimbursed me, that's a public activity. If I apply for a passport, that's a public activity. If I apply for a job, that's a public activity. Or it is unwarranted invasion of the privacy of the individual. Now, what's privacy? Is a $1 million question. Puttaswamy judgment says privacy is a fundamental right of citizens. Fair enough. But what constitutes privacy is not being defined in the Puttaswamy judgment. I would submit you should be reading it in consonance with Article 19(2). In Article 19(2), sovereignty, etc., is something for which some reasonable restriction can be put. The only two words that will relate to privacy: decency or morality. If giving some information would result in violating decency or morality, it should not be given under RTI. And because it was understood that the PIO will find it difficult to identify this, an acid test was given only for 8(1)(j), provided that the information which cannot be denied to Parliament or a state legislature shall not be denied to any person. Anybody claiming exemption under 8(1)(j) must say that, in my opinion, I would not give this information to Parliament, and that is information that would violate decency or morality. All other information has to be given. Supposing you don't get the information properly, then you can file a first appeal to First Appellate Authority within 30 days. For not getting information, incomplete information or wrong information, First Appellate Authority should decide in 30/45 days. If result of first appeal not satisfactory, file second appeal to the Commission within 90 days. Section 19(5) says, onus on PIO that denial of information was justified. Section 22 of the Act is a very important section. The provisions of this Act shall have effect notwithstanding anything inconsistent therewith contained in the Official Secrets Act and any other law for the time being in force, or in any instrument having effect by virtue of any other law other than this Act. Quite often, this gets into a legal tangle. Somebody says under company law, this is laid down. Somebody says under RBI laws, this is laid down. Somebody says Supreme Court rule says this. This conflict has been avoided by Section 22. As far as giving of information is concerned, the RTI Act overrules all other laws. 23. No court shall entertain any suit, application, or other proceeding in respect of any other order made by under this Act, and no such order shall be called in question otherwise than by an appeal under this Act. No appeal lies beyond the Commission, but a challenge may be accepted by a High Court in its writ jurisdiction. What is writ jurisdiction has been laid down clearly. Unfortunately, a lot of appeals to the Commission's decisions are being made to the courts, and the courts are accepting this merely by labeling them as writs. Section 20 of the Act is very important. If information denied without reasonable cause, Commission must penalize the PIO, deemed PIO at ₹250 per day of delay after giving an opportunity of explaining. Maximum penalty ₹25,000. Commission can also recommend disciplinary action against the officer and compensation to be paid to the applicant. This is the teeth of the Act. This is the reason the Act works. This establishes the sovereignty of the individual. Because you are the sovereign, disrespecting your right, the PIO has to pay a penalty from his own pocket. From his salary, the amount is deducted at ₹250 per day of delay. For example, if Akbar Badshah or Shivaji Maharaj had asked the courtier something and they had refused to answer, they would have probably put them in prison. You don't get to put them in prison, but the person pays a personal penalty. This is the only law where disrespecting the citizen's right results in a penalty, penal consequence for a public servant. Therefore, it establishes the key concept of democracy, the heart of democracy. Appeals. I just put it in a format. RTI application information in 30 days. If no response received or unsatisfactory response, first appeal to be filed within 30 days of response or 60 days in case of no response. First appellate authority order after hearing within 45 days. If unsatisfactory order or no response, second appeal to commissioner within 90 days of first appellate authority's order or 120 days from the date of first appeal if no order received from first appellate authority. RTI has been used by ordinary citizens, and every year about, in my estimate, is 60 lakh to 1 crore RTI applications are being filed across the country. When you get a form, you don't go anywhere to get a form. Any plain piece of paper is your application form. You can do it handwritten, you can have it computer generated or typewritten. Some states have got formats. Maharashtra has a format. Central government has no format, but you can use this format for central government. Other states, you have to look on the rules in the website. Now, this is a story I want to share about RTI application. In 2006, a young boy from a small village came to Mumbai looking for a job. Where did he stay? He stayed in a slum with his uncle. And he was going around trying to find contacts to get a job. In the Basti, there was a RTI workshop being held. We hold RTI workshops in all kinds of places. He sat down since he had nothing to do, understood that RTI is information on records, that he must apply to the public information officer and the address where the application information is likely to be, that he needs to pay a 10 rupee application fee. Having understood all this, he moved on. After a few days, he got a job, and then he needed a ration card. So he went to the rationing office, submitted his application. As he was going out of the door, the peon accosted him and said, "Aapko ration card chahiye kya?" He said, "Haan bhai, isliye to form bhare." The peon said, "Chai pani lagega." The boy said, "Theek hai, aapko chai pila dunga." The peon said, "Chai pani ka matlab chai pilana nahi hota hai." So the boy said, "What does it mean?" Said, "You'll have to pay 2,000 rupees. And this boy, without batting an eyelid, gave a response that always makes me feel very proud. He said, "I shall not give a bribe." The peon shrugged, said, "Stupid chap coming from a village doesn't understand how cities work. You don't need a ration card, tum jao." After 3 months, this boy filed an RT application, which I'm showing you. I'd given an application for a ration card on 5th August 2006. Photocopy of receipt attached. I want the following information about its progress in the following format. He sought the detail of which officer had the application, what action did he or she take, on what date was it taken, and so on. 2. I want a list of ration cards issued in the last 2 months, giving the dates on which the applications were made and the dates on which the ration cards were issued. Now, it's obvious that these have to be on record. And if this information was provided, it would expose the fact that without any legitimate reason, his ration card had been stopped. Next day, the same peon came to his house and said, "Aapko saamne bulaya hai." He went to the rationing office, and the officer, as soon as he saw him, said, "Arey, ye aaye hain, inke liye ek kursi leke aao. Inka ration card leke aao aur ek cup chai aur ek gilas pani leke aao." He did not give chai pani. He got chai pani instead. And to me, that 1 cup of tea is respect for the Indian sovereign citizen. RTI is far more than just certainly getting information, keeping a check on government, exposing corruption. All these things are there. But more importantly, it is a matter of ensuring the respect to the sovereign citizen of this nation, the Maharaja, the Lok Shah, the Badshah or Begum of this nation. This is another application that I had filed. I'll tell you the story of this. This is to explain there are good government officers, but we need to do something to make them work. We need to support them. One fine day, when I made this application, I was just an ordinary citizen. I was not a commissioner. I was an ordinary citizen of Mumbai and an RTI activist. One fine day on the Times of India front page, I saw a big photograph of citizens demonstrating at one place in Mumbai because one police constable, More, had raped a minor. On the same day on page 5, I saw a small news item. This small news item stated that Police Inspector Prakash Avare of Mumbai Police had raped a minor the earlier year. The evidence was clear. He was suspended from service and the case went to court. In court, evidence was not adequately provided, hence the court dismissed the case. And Police Inspector Prakash Avare was being reinstated in service. When we read such things, we feel angry. I also felt angry. So I said, let me try right to information. This is the information I sought. According to a news report in the Times of India dated 29 April 06, Inspector Prakash Avare was accused of raping a minor girl in September 2005. He was acquitted by the Sessions Court in February and has been reinstated in service. I want a photocopy of the order reinstating him, along with which the file notings based on which the decisions were taken. I was seeking information of the record only. I did not say why are you keeping him, etc. But this was intended to put pressure. The PI refused this, and therefore I filed the first appeal, which I am showing you. The grounds for appeal, facts of the case. I had asked for information regarding the reinstatement of Inspector Prakash Avare as per the attached application. PI first refused, stating that the information would be provided by Bhaikala police station. PI of Bhaikala replied by his letter of 16/5 that the information could not be provided as it was exempt under section 81H, which exempts information which would impede the process of investigation or apprehension or prosecution of offenders. Grounds for appeal. PI has not shown how providing the information would impede any investigation. In fact, no investigation is being held since Prakash Avare is being reinstated. The rejection is without any basis in law. There was a very good Deputy Commissioner of Police who had called me for the hearing. I had gone. I repeat, I was not a commissioner. I was no government officer. I was just an ordinary citizen of Mumbai. The DCP understood what I'm saying and he said, Mr. Gandhi, but what can we do? The court has given the order to dismiss the case. I said, that's all right. That's as far as the court process is concerned. From my perception, and I'm only asking for a record of what was written in the record reinstating him. And from my perception, there are two possibilities. Either Prakash Avare is guilty of the crime he's alleged to have committed, in which case reinstating him is gross disservice to the police force, to the citizens, and to the rule of law. Two, alternately, Prakash Avare was innocent. In that case, somebody targeted and fixed him. Such a person must be framed. Whoever framed Prakash Avare should be penalized. How does this work? The DCP saw the point I was making and said, Mr. Gandhi, give me some time, let me see what I can do. In 20 days, I got it in writing from the police commissioner's office that Police Inspector Prakash Avare had been dismissed from service under disciplinary action. That is the power of right to information that an ordinary citizen can do. Sitting at home, you can get such results. There are very honest government officers, rare. These are not routine things, but things have been corrected by such applications and by honest police or other officers in the public service. We need to do something about it. The summary I'm providing, no specified format for application and first appeal, useful to use Maharashtra format for central government. Application fee ₹10, most convenient. We will also file it online RTI applications. In these 4 places I've identified. For others, look up the websites. What does this show? We have a right which is extremely simple to use. It will not take you more than half an hour to make an RTI application. The total cost, including speed post costs, etc., is unlikely to be more than 50-60 rupees. An appeal to all of you. consider filing one RTI application once a month on a subject that you desire. A survey of mine shows that all Indian citizens crib for 2 hours every month. What is wrong with India? Corruption है, ministers ऐसा करते हैं, political class ऐसा करते हैं, वो ऐसा करते हैं, ये ठीक नहीं है, वो ठीक नहीं है. My submission is continue cribbing for 1.5 hours a month, so that cribbing will change nothing. Half an hour in a month, take out to file one RTI application about a subject that is of concern. You read something in the paper, you see something wrong happening, or something wrong happening with you. Please remember, it's not a grievance redressal mechanism. Some of the cases I've talked have redressed grievances, but this is not a grievance redressal mechanism. But that puts pressure on the government. My own finding is that in about 15 to 20% of the cases, only 15 to 20%, sometimes they may give the information, sometimes they may not. But some small change occurs in the governance. Even if they've done a wrong thing, they defend it, may not give the information, but next time round, they will not commit the same mistake. Here's the dream I want to share with you. If 50 lakh Indian citizens, and that's not a very big number, if 50 lakh Indian citizens take a vow to file one RTI application once a month, 6 crore RTI applications will be filed in a year. 15 to 20% of that, about 1 crore times, if a small change occurs in the governance of India, India will change and democracy will become a true Swaraj that we wanted. You and I are the citizens who are the rulers of this nation. If India has problems, I think you and I are also responsible. We need to correct it. One lecture where I was talking about RTI like this, one gentleman my age people are slightly cynical. He got up and said, Mr. Gandhi, मैंने 10 साल कंप्लेंट किया, रिप्रेजेंटेशन किया, मिनिस्टरों को लिखा, आरटीआई एप्लीकेशन किया, कुछ नहीं होता है. इंडिया में कुछ होने वाला ही नहीं है. To such people I say, to such friends I say, many of us go to mandirs, masjids, gurudwaras, churches, derasars, agyaris, what have you. Once a day, once a week, once a month, once a year maybe. When you go there and come out, you don't find an extra 100 rupee note in your wallet. It does not look as if you become smarter, handsomer, more beautiful, more youthful. Nothing like that happens. Why do you do it? You do it as an act of faith. You have faith that by doing this, something good will happen to me, my family, my friends, my society. What do we do for the nation as an act of faith? Here is a simple tool you can use to do your duty for your nation. Patriotism is not merely standing next to the flag and singing the national anthem. Patriotism means the feeling that I will do something for the nation. You are the sovereign, you are the Badshah or Begum. At the end of this talk, I'm hoping I've convinced you to use RTI frequently. Even if you are not convinced, please believe the fact that you are the Badshah or Begum of this nation. Badshahs or Begums have responsibilities. They don't only have authorities. Please exercise your responsibility to the nation. Mera Bharat Mahan, we often say. We don't really believe it, do we? Therefore, I say, Mera Bharat Mahan nahi hai. Mera Bharat Mahan nahi hai, par ye dosh mera hai. I, the individual sovereign citizen of this nation, am responsible. And I will do my duty. I will bring change. You will bring change. All of us together can bring change. We need not come together. Independently, individually, RTI gives us the tool to make a difference to this nation. Thank you very much. Thank you.
Thank you so much, sir, for that wonderful presentation. I think the way you presented yourself, sir, the participant did not had to raise any question because every aspect of the RTI.
Just one thing, Vishal.
Yes, sir.
I would welcome questions and also feel free to dispute what I said.
Right, sir.
Don't have to necessarily agree with me. I'm a Buddha, but I am happy to learn from you.
Okay.
Feel free to challenge anything that I have said. Disagree with me.
Sure, sir. Okay. Dr. Nagashima, you can unmute yourself.
Sir. Sir, good evening, sir.
Good evening to you.
Sir, a small clarification. Whether the employee, the subordinate employee can ask the superior employee to give the clarification with regard to their any queries, sir?
No, I repeat, clarification. See, what is on record is to be given. A clarification is not on record.
Yes, sir. Yes, sir. If you are given any request or anything, what you can say that. So that clarification we can made from the superior employer, sir.
No, I repeat. No, it is not a matter of superior and inferior employee. When you are saying the clarification, that means there is no record of it.
So, for example, I have given a letter to our commissioner, sir.
Right.
And then there is no reply from him. So, shall I ask that reply from the through RTI reply?
You can ask. Let me explain this. Very good example you've given. What you can seek is not why have you not responded.
Yes.
If this has been responded to, give me a copy. If this has not been responded, please state so.
Okay.
Convert it to asking for a record. If the record is not there, that is your answer. That means answer has not been given.
Yes.
Or progress of the letter that I sent you. What did you do? Like the ration card man asked for information about the progress. After I received the letter, what action did you take and what action has somebody else taken? If they have taken no action, they'll have to respond saying we have taken no action. It's not a grievance redress tool. Then you will have to resort to some other method.
Sir, I will tell you very clearly. So I given a letter to the commissioner with regard to my what you can say that so that is a seniority. So seniority.
Right.
But I given the letter, there is no response from the commissioner. Can I ask this seniority in the RTI Act, sir?
You can ask for seniority. That's on record. That has to be on record. You can ask for what's your seniority. That you can certainly ask. Just think of one thing. What you are asking is not interrogation. What you are asking has to be on record.
Yes, sir.
Okay. Thank you so much, ma'am.
Thank you, sir. Thank you, sir.
Thank you.
Next question is from Mr. Deepak Gala.
Yes, Deepak.
Sir, I want to know if there is any mandatory in any state in filing the application in only format.
Some states have such format. Some states have. For example, Maharashtra has a format. Once a format is given, that is a right they have in the rules to specify a format.
But sir, it is not mandatory, no sir. We can file in plain paper also, no sir.
No. You can file on plain paper, but follow the format.
Format is not mandatory, sir, in the Act actually.
No. You see, what is not in, look at law like this. What is not banned in the RTI, in the Act can be done. The Act does not say there can be no format. Rule-making authority has been given to states. So if some state has specified a format, it can apply, and that is not against the law. But it cannot say a form has to be obtained from the government.
But if suppose to do not file in format, it can be rejected, sir.
Some people may reject it, and that's a matter of dispute because if the state rules have said a format, then you should follow the format.
Okay, sir. Thank you.
Thank you. And the next question is from Dr. Pranay.
Yes, Dr. Pranay.
Good evening, sir. Am I audible to you, sir?
Yes, doctor.
Okay, sir. One common perception is that the police people, they deny providing information on a simple clue that the matter is sub judice. When someone is arrested, or even if the matter is sent to the court for prosecution, etc. Now, is it legally provided, or how can your suggestion, how could we make the policeman compelled to provide the information if such information is not against the law?
if you are saying the rejection is based on the statement that the matter is sub judice, it is an illegal rejection under section 81B. 81B exempts information provided there is an express order of the court. So what you should do is, in case of such a rejection, file a first appeal, say that give me a copy of the order which prohibits disclosure. Sub judice has not, Parliament knew the word sub judice. Sub judice word has not been used in the exemption, therefore it cannot be denied. It's an illegal denial.
So what is your suggestion to rectify such kind of practices by the police?
File an appeal, my friend.
Okay. Fine, thank you.
Sir, would you like to take one or two more questions?
Yes, I have no problem.
Right, sir. So next question we have from Dr. M.K. Jain. Dr. Jain?
मेरी आवाज आ रही है?
Yes, sir.
हाँ, मैं हिंदी में बात करना चाहूंगा. हेलो.
हाँ, बताइए.
हाँ, किसी एम्प्लॉय की ACR की कॉपी ली जा सकती है RTI में? एनुअल कॉन्फिडेंशियल रिपोर्ट.
हाँ, अब ये थोड़ा सा कंट्रोवर्शियल मैटर है. मेरे हिसाब से इफ आई इंटरप्रेट द कानून स्ट्रिक्टली दी जा सकती है, मगर सुप्रीम कोर्ट रूलिंग ये है कि नहीं दी जा सकती है. मेरे हिसाब से सुप्रीम कोर्ट का रूलिंग कानून के खिलाफ है, कॉन्स्टिट्यूशन के खिलाफ है, मगर ये परिस्थिति है. मेरा खुद का, मैंने ऑर्डर्स में ACR की कॉपीज दी हैं लोगों को, किंतु मैं ये भी मानता हूं कि सुप्रीम कोर्ट का रूलिंग है कि नहीं देना.
सर, कोई अगर नंबर बता दें केस का तो हमें थोड़ी सी हेल्प मिल जाएगी.
सॉरी,
केस नंबर वगैरह का है कोई CIC का कोई केस नंबर?
किसके बारे में? कमिश्नर,
ये जो सुप्रीम कोर्ट का जो बता रहे हो कि
आप मुझे, अगर सुप्रीम कोर्ट का जो निर्णय है, गिरीश रामचंद्र देशपांडे, आप टाइप कीजिए गूगल में.
जी.
गिरीश रामचंद्र देशपांडे RTI सुप्रीम कोर्ट जजमेंट, वहीं से मिल जाएगा आपको.
जी, थैंक्स अ लॉट सर. थैंक्स.
यू वेलकम.
Okay, so sir, I think we shall end with the question answer session, otherwise it will go on for a long time, sir.
Your choice. You are the boss.
No, sir, I'll just take down the questions. If possible, I'll mail the questions to you, otherwise the session
Okay. And Mr. Bera, my request is,
Yes,
please
sir.
share the presentation and
with all the participants.
and the primer with all the participants.
Surely, sir, I shall do so. I shall pass over the mic to the Associate Professor, Dr. Ashish Kumar Singhal, sir, for the vote of thanks.
Thank you, Vishal, sir. You gave me the opportunity to give the vote of thanks. It is my pleasure. Good evening, one and all present here. Chief guest of today's International Special Guest Lecture, Mr. Shailesh Gandhi, former Central Information Commissioner and an RTI activist, Brigadier Rajiv Sethi, Registrar ICFI University, Assistant Dean ILS, Mrs. Monica Carola, faculty members, and all students from ICFI Law School, the ICFI University, Dehradun, and the other joining from the other colleges of India, faculty members and the students. I, Dr. A.K. Singhal, welcome all of you on behalf of ICFI Law School, ICFI University. It is such an honor for me to get the opportunity to thank you all present here. On behalf of ICFI Law School, the ICFI University, Dehradun, I extend a warm welcome to the people of gathering. I would like to express my gratitude to our honorable chief guest to take out time from his busy schedule to grace the National Special Guest Lecture on Right to Information Act 2005. Thank you, sir. Thank you. Our students, we all the faculty members, we have got the knowledge from your kind words. You inspired us, you encouraged us with your kind words, and you also gave us the brief about the various provisions of right to information. You described us about the act provision, the cases which you handled. I also saw about more than 20,000 cases you settled within the 3 years and 9 months. You also described us about the different aspects of right to information. And I also make a special thanks to Ms. Anushmi Jain and Mr. Vishal Bera, Faculty Convener, Faculty of Law, for immense support and organizing a well-mannered guest lecture of today. I must thank the entire team of ICFI Law School, faculty and the students for working hard to make this guest lecture a great success. Thank you, sir, for your kind words, valuable words. We also give you the thank relating to the procedural aspects about the RTI. Thank you, sir. Thank you all. Thanks. And it's over to Vishal, sir.
Thank you so much, sir, for the vote of thanks. Thank you so much, Gandhi, sir, for your lovely presentation, which actually briefed us regarding the RTI. And Monica, ma'am, thank you so much for being there. Aviral, sir, thank you so much for connecting us once again with Gandhi, sir. Thank you so much. Thank you, Anushka, ma'am. Thank you, Monica, ma'am. So, with the
Vishal?
yes, ma'am.
Yeah, I would also like to thank our chief guest who has, there are so many questions which are coming and people keep getting that it's wonderful to have lectures like this where the problems and issues of people also get resolved over the, guest lecture. So, sir, it's been wonderful listening to you, and I'm sure that if we have any issues relating to RTI, we'll be able to contact you for further, your inputs on anything. Thank you very much for being here, and thank you to Mr. Aviral for the help that he does on and off to ICFI Law School. Thank you, Vishal and Anushmi.
Thank you, ma'am. Thank you, Aviral, sir.
And my salam to the Badshahs and Begums of India.
True, Shailesh. Thank you so much.
Thank you. With the permission of the speaker, should we shut down on the event?